States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Be seated. I want to welcome everyone to the Fourth Circuit Court of Appeals on this 80th anniversary of the attack on Pearl Harbor. And I'm probably the only person in the courtroom who was alive at the time. But we have three good cases, and in the first case, Porter versus White, number 20/13, Mr. French, representing Mr. Porter. Good to have you with us, sir.
Thank you, Your Honor, and it's good to be here. May it please the court. It's undisputed in this case that Juror Treacle answered 3 voir dire questions dishonestly, and that the information that he failed to disclose went directly and was directly relevant to the issue of his ability to be impartial in what was at the time a capital murder trial involving the shooting death of a police officer. When viewed under the totality of circumstances, the information that Juror Treacle withheld and the reasons he gave in his testimony for withholding that information demonstrate that he lacked both the capacity and the will to decide the case solely on the evidence. It's well established in the Fourth Circuit, this court held in U.S. versus Jones, that trial courts have a very broad discretion in exercising in making the determination as to whether or not to excuse a juror for cause. And under Virginia law, under Supreme Court Rule 3A.14, courts have the ability to exclude any juror for any reason if the court has any reason to believe that the juror is not or might not give a fair and impartial trial. And under long-standing Virginia law, if there's any reasonable doubt about a juror's qualifications to be impartial, those doubts
the fact that the district court didn't find that the juror intentionally withheld information during voir dire?
Well, Your Honor, we believe that those findings, first of all, were both highly speculative and also internally contradictory.
So were they clearly erroneous?
We believe that they were clearly erroneous.
And that's what they have to be, is it not? For you to prevail today, you've got to convince us that there was clear error in that regard.
In
the determination that the juror was credible. And that's what Judge Hudson said.
That's correct, Your Honor.
And it has to be clear error.
With respect to those specific findings, and if I could address those specific findings as well.
No, but for you to prevail, there has to be clear error.
There has to be, well, I think there's a mix. So whether or not he intentionally withheld information or whether he credibly testified that the information that he failed to disclose wouldn't have had any impact on his ability to be impartial.
But for you to prevail, the determination finding by Judge Hudson that the witness was credible, the juror witness was credible, has to be clearly erroneous.
Yes, I believe that that's correct.
Right.
Although
so how was it clearly erroneous?
Well, first of all, with respect to the credibility findings that the juror testified that this information would not have impacted my ability to be impartial. As a threshold matter, at least twice in the district court's opinion, the district court noted that Juror Treacle testified that the information he failed to disclose did not, in fact, impact his ability to be impartial. which from our perspective is prohibited under Rule 606.
How would the district court know that?
Well, we objected during the proceedings. We objected on the basis of speculation.
Right.
But when the other side, but I would say even more so, aside from just those particular findings about whether what the juror testified to was that the information he failed to disclose would not have had any impact on his ability to be impartial. And I would suggest to the court that that is rank speculation. The only way that the juror gave that testimony 12 years after sitting in voir dire, after having sat through an entire trial, having voted to convict the defendant and having voted to recommend the death penalty, and then made those comments in the context of a proceeding that was directly involving why he failed to answer those questions honestly. So we would argue that those credibility determinations and those factual findings are clearly erroneous when we couple that with all the other information that he testified to at trial. And even if we say that his testimony was credible, the only thing that would have been credible was the fact that he believed 12 years later that he could have been fair and impartial. It doesn't mean that he was at that time. It simply means that he believed that after the fact. The district court in analyzing the second prong of McDonough limited its analysis to whether a valid basis for a for-cause challenge existed, to whether or not we had established either actual bias or implied bias. The court didn't provide any consideration at all to the discretionary authority that courts have.
Counsel,
Yes.
Can I ask you a question? Because I found this part of your brief somewhat confusing. So under McDonough's second prong, you have to show that what would have been the correct response on voir dire would have given rise to a for-cause challenge, a valid for-cause challenge, right?
Yes, although
That's what it says.
the court, well, that's in McDonough, right, that it would have provided a valid
Okay.
basis for.
So are you arguing that not the fact that he, on your account, that he lied at voir dire, but the actual information? Yes, I have not one, but 5 relatives in law enforcement. Is your position that had he said that, that would have given rise to a valid for-cause challenge?
Yes, yes.
And what is the case law support for that? I couldn't find anything.
Well, the case law doesn't support that that it's an automatic or a required per se disqualification, but that's under an implied bias analysis. The court also has the authority to do is to look and determine whether or not the information that's being provided, I think the way one court talked about it was bespeaks a risk of impartiality, of a lack of impartiality.
But is there any case ever saying that because you have law enforcement relatives, that means you are disqualified from sitting on the jury?
I haven't found anything but I believe the case law talks about that it frames that in terms of a per se disqualification, as opposed to if this is a individual who had 5 family members who were engaged in law enforcement, involved in law enforcement, in a capital murder trial involving the shooting death of a police officer. It's hard to then go back and subjectively say, well, did this, who would have moved? Would the prosecution, or rather, would the defense have moved to disqualify the juror in that case? But I think that
Well, they could have moved all they wanted, but the question is whether they would be discharged for calls. And they might, all that information might have been pertinent to and whether you exercise a discretionary challenge or something.
Your Honor, I think one of the issues that I think is important is to understand that when we're talking about McDonough, if that decision, that determination is being made within the context of a case where the juror has already withheld information. So the court, this is a First Circuit case, but in the Sampson case, essentially said that the real question in terms of determining is there a valid basis for a for-cause challenge under that second element of McDonough is whether in the totality of circumstances, the information that was withheld and the reason why it was withheld would, under the totality of circumstances, would lead to the court to determine that this juror was not able to be impartial.
Here, the reason was he didn't remember it, and that was it.
Well, I think the facts, Your Honor, is that what he actually said is, I just didn't think very hard. These were questions, these were simple, short, straightforward questions that specifically asked about family members. And yet Juror Treacle testified when he got into court, I didn't think about family members.
And didn't he also testify that right before the trial, his brother, who was the police officer in the county in question, told him, if you tell that I'm a police officer, you won't get on the jury?
He absolutely did, Your Honor, and that was another point we wanted to make, and that's a point that the district...
credibility to think that, for him to say that he didn't recall that.
It does, and it also flies in the face of the notion, I think the district court...
But the credibility was determined in his favor by the finder of fact.
It was...
That's the issue you got here, is how you say, how we find that he was incredible when the judge said he's credible. And he sat on the witness stand and the judge saw him and listened to him. And he said, and he heard the evidence, all of it.
And Your Honor, I would again argue that what he found credible was essentially...
I know that's what you have to argue. That's what this case comes down to. And under the law, though, we give deference. We have to give deference under this clear error standard to the district court, to the trial court, to the finder of fact.
I understand that, Your Honor. I think one of the issues that's important to understand is that, yes, is while there may have been some evidence to support the trial court's decision, the question for this court on a clearly erroneous standard is, does the record as a whole give this court the firm conviction that a mistake was made? I think when we look at the other testimony, we have Juror Treacle's brother telling him before he goes to when he learns that he had been summoned for jury service, telling him that if you reference me, you may not get picked for jury service.
Can I ask you just a question about the chronology of how this information came out? As I understand it, the first Juror Treacle gives his deposition where he says, of course I didn't think about my brother. Why would I think about my brother? And then, am I right that after that, the brother shows up at the hearing and says, actually, I talked to him right before voir dire and told him you might not get picked if you talk about my law enforcement background. So that when Juror Treacle was giving his deposition, he didn't know that his brother was going to come in and cut the legs out of everything he said, right?
That's correct. And we asked Juror Treacle during his deposition who he told that about his jury service, and he said he only spoke to his wife. Did the district
court address this sort of fatal inconsistency at all?
No. The court made reference to that to Purnell Treacle's testimony, but did not address the consequences of it. And that's part of our point of why we think we can make the court can find these findings clearly erroneous, because much of what Juror Treacle testified to was very contradictory. On the one hand, he says, in the district court found that he steadfastly believed that he mentioned Purnell on voir dire. At literally in the same paragraph of the district court's opinion, the district court quotes his testimony of saying, I don't remember thinking about my brother Purnell when I was in the courtroom. He talks about the court found that Juror Treacle had said, I sort of blocked my brother Ronald Treacle out of my mind. Ronald was the one with a long history of criminal involvement. I would argue that it strains credulity to believe that anybody could forget and block a brother out of their mind, particularly when the testimony is that the very reason he blocked his brother out of his mind is because he was always getting in trouble. He was always going in and out of jail. He was going around threatening people. The notion that there were 3 voir dire questions, and I think what we have to take into consideration is that when we're considering the court's analysis or finding that this was simply inadvertent, is that he failed to disclose multiple family members in response to 3 different voir dire questions. Those voir dire questions specifically asked about family members, and yet he says, I didn't think about family members with respect to the voir dire question about arrests. He says, I knew I had never been in trouble, and so that I only thought about myself.
Can Can I ask you a question that reminds me? It seemed to me that at different parts of your brief, you were talking almost about two different theories of what bias might look like. One is sort of the traditional, I think what we usually think of, like this juror had an axe to grind. He wanted to get on the jury because he had a predisposition about how the case should come out. But the other, and I think you quote this in your brief, is that just sort of a lack of capacity or willingness to follow the court's instructions, to take this job seriously. You're a juror in a death case. You're not listening to the questions. You're not answering honestly. You're just, the Ninth Circuit in the Dyer case talks about like, this just introduces this kind of random element onto a jury, and we can't have that. Are you arguing both of those basically?
Well, I think that what we're arguing is that I think the testimony, the facts do merit an inference of actual bias. However, I think the key issue here is really that issue, which is, and that's what the Sixth Amendment speaks to. It's an impartial jury, and impartiality is based on whether the juror has the capacity and the will to follow the law. And in this case, we have a juror who was seated, and I think it bears emphasis. At that time, he was on a jury panel in a capital murder case involving the shooting death of a police officer. I would argue that would capture the attention of most reasonable individuals, that they would listen very carefully to the questions that are being asked of them. He demonstrated on that very first day that he was incapable of listening to the instructions that the court gave, despite the fact that he was under oath, despite the fact that the questions specifically asked information about family members. I think he demonstrated very clearly. You don't have to speculate or hypothesize. It's as plain as day. He was not capable of serving in an impartial way. If a juror doesn't listen to the questions and admittedly says, I didn't think very hard, other jurors throughout the voir dire were pointing out things like, I have a cousin who's a police officer in DC. Well, Juror Treacle had two cousins who are police officers just a hop away in Philadelphia. That didn't apparently trigger any recollection in his mind. I see I'm out of time.
Thank you very much, Mr. French.
Thank you.
Mr. Dillingham?
Milligan, yes, thank you.
I'm sorry I mispronounced your name. It was good to have you here.
Thank you, Honor. May it please the court, Matthew Dolligan, Senior Assistant Commonwealth's Attorney, Attorney General. Commonwealth's Attorney's been years ago for the warden. I think it unfairly characterizes the district court's opinion to say that the only thing it looked at was whether there was a per se grounds for per se exclusion. Judge Hudson did follow the direction in folks in the cases it cites to consider that and find there in fact was no per se exclusion, but went well beyond that, found that there was no evidence of bias from the answers given at voir dire and from the much more extensive answers given and produced at the hearing, and found that all that information taken as a whole did not show that the juror was biased, did not have any actual bias in the event, was able to hold fairly between the parties. And while it is focused in the second step of the Donna analysis on for cause and mandatory for cause strikes, the district court did address what's been cited under the state grounds for strikes for cause, and the seventh ground, the ability in the view of the trial court of the juror to follow instructions and to generally act impartially, kind of a
Mr.
catch-all.
Delegan, is there anywhere in the record that indicates that the trial court would not have excused the juror for cause if he had answered the questions honestly?
The district court found that repeatedly, that the information.
I was asking about the trial court. Is there anywhere in the record that the trial court would not have excused him if he had answered the questions honestly?
The trial court would not have granted a strike for cause based on the information he didn't provide. I'm sorry, I'm not sure I appreciate the question.
How do we know that the trial court would not have struck this juror if he had answered all those questions honestly?
Of course, the holding of this court on the remand was we don't know what his answers would have been until we had this evidentiary hearing and found out. So I don't believe that was ever presented to the trial court, how it might have ruled had it had this information.
And what did the district court say about that?
The district court said that the various grounds, I'll go into more detail, but in each case said that these would not constitute grounds for a for-cause discharge, both because there is no per se rule based on any of these categories of information, and because in listening to the defendant, listening to the juror rather, listening to his explanations, he found credible that he was not withholding information out of any improper motive, out of any desire to sit on the jury, or out of any bias. And therefore, there was not ground to exclude him.
What did the the district court say about the discrepancy between the juror's testimony and his brother's testimony about that conversation they had before he went to be a juror on this trial?
Broadly, the district court said that it found credible Treacle's explanations for what he did. Specifically, it noted in one footnote that Juror Treacle had said that he only told his wife he was sitting on the jury, that he hadn't had this conversation with his brother.
Wait, is it?
So the district court found the brother was not credible, but the juror was credible?
The district court found the juror was credible. I don't believe he made any specific credibility findings about Pernell Treacle.
Right.
Does the government have a theory for how you can reconcile Juror Treacle's testimony that when he was sitting in the courtroom at voir dire, he simply never thought about his brother? There's a question, do you have law enforcement relatives? Just didn't occur to him to think about his brother. How you reconcile that with the brother's testimony that shortly before that, the brother talked to Treacle about the fact that he is in law enforcement in connection with his jury service and tells him, if they find out that I'm in law enforcement, they may kick you off the jury. How can both of those things be true?
Well, at least two ways. Well, one, Pernell Treacle's recollection could be mistaken, and he didn't have the conversation.
So that goes back to Judge Thacker's question. You need us to discredit Mr. Pernell. We have to think he was either being dishonest or was incorrect in his memory of this conversation. Because I don't think the district court made that finding, so I don't see how we're supposed to.
District court didn't make either finding on that.
No, I said there, if I may ask,
People have different recollection.
So what's the other way to reconcile?
The other way,
Same event.
the other way you would reconcile it is that Juror Treacle didn't remember the conversation that his brother testified to.
That seems, okay. I will just tell you, let me ask you the question this way. Assume for a minute, I don't think that's plausible. I don't believe that Juror Treacle asked to identify law enforcement relatives, thought about his nephew, but not the relative who told him shortly before that, in connection with the jury he's now sitting on, if you mention I'm in law enforcement, they may not seat you on the jury. Let's assume I don't find what Juror Treacle said at his hearing to be plausible. And to the extent the district court credited it, I think that was clearly erroneous. Where does that leave me?
Well, that still leaves with the ultimate question in a McDonough case. If you believe...
What about over under actual bias? If I think that he gave a purposefully dishonest answer at voir dire and then lied about it at the hearing, is that enough for actual bias, or do I still need more?
I don't think that's enough for actual bias. It does not identify any motive, any prejudice, any other grounds that would prohibit or give reason to believe he could not sit fairly in the case. And the district court did repeatedly make that finding, that on the whole of the evidence that was produced at the hearing, there simply was not evidence that Juror Treacle was biased, could not have been impartial or that there were any grounds to excuse him. If you do not believe his recollection, he is perhaps at best a poor historian of family events and
Well, I thought you were
Not a-
saying something different, which may be right. He might be an enormous liar. Maybe he lied at voir dire and then lied at the hearing, but that's different from being biased. I understood you to be saying that.
yes, that was my first point. I was
Okay.
moving to something else, but that was, I hoped presenting that as the question to answer to your question about how we resolve this. He's still not biased. I also think it's a difficult way to view the district court's job here to claim that we've referred this matter to the district court to examine what further questions might have been asked at voir dire 12 years ago, what further answers might have been given to those questions at voir dire 12 years ago, to bring in witnesses to ask them to recall what happened 12 years ago, and then ask when they give the answer that petitioner doesn't think helps his case, to believe we shouldn't believe them because it's 12 years ago. The witnesses in the district court have what they have.
In fairness, counsel, the way to avoid that is if jurors actually answer the questions honestly at voir dire. The reason we have to do this retroactively 12 years later is because juror Trico, for whatever reason, gave untruthful answers to 3 separate voir dire questions. That's why we have to do this after the fact. I don't think it's really fair to pin that on the defendant.
I apologize if I wasn't clear. I don't pin on the defendant, as you say, the idea that we have a McDonough claim in front of us that we need to resolve. What I'm criticizing is the argument offered earlier here this afternoon, as I took it, that because their memories, particularly juror Treacle's memory, is imperfect and sometimes inconsistent 12 years later, therefore he's lying. It may just be that it's 12 years later.
Can I ask you a sort of a separate question? Even on the district court's understanding of everything that happened here, and so I call this sort of the best case scenario, there's no intentional non-disclosure. Don't we still have a juror who has basically shown himself either unable or unwilling to follow the rules of a trial? He's not taking seriously the court's admonition to answer truthfully. He says as an explanation for his own answers, I wasn't listening. Like they said family, but I decided that I would just think of the question in terms of myself. I mean, don't we have, and this is from your brief at page 18, a juror who cannot conscientiously apply the law and find the facts? It just doesn't seem like even on the district court's understanding of what happened here, he's just not taking this very seriously.
Well, the district court found specifically that there was nothing from which it would conclude that the juror was not capable and willing to decide the case solely on the evidence before him, quoting the Smith case, I think. So we have the finding that juror Trico was capable of doing that, even with the imperfect recollection now and arguably at the time of voir dire and the information he omitted. That the information didn't show bias and the information did not show to the district court's finding that he was unable to follow his duty as a juror and decide the case on the evidence.
Well, but on that question, sort of how did he perform as a juror? Could he follow the questions? Did he answer truthfully? The district court sort of doesn't have any better vantage point on that than we do, right? We're both looking at the same cold record of what happened at voir dire. And I guess I understand about deferring to the district court in judging Mr. Treacle's credibility. But like there does seem to be no doubt, and the district court doesn't dispute this at all, and I don't think you dispute it, that he answered 3 questions incorrectly, and that his explanation for that was that he wasn't listening or that he sort of interpreted them to be about something other than they were about. And I mean, that's just facts on the record. And whether we draw from that he was able to follow instructions or that he was not able to follow instructions, I don't really see how that's not more a legal question than a factual question.
Well, what we've asked the district court to do, what we asked in any McDonough case for the court to do, is put itself in the position of the court as if it was conducting voir dire, as if the answers had been given that were omitted and making judgments about whether there's grounds for strike for cause. When we do that at trial, those are intrinsically trial court decisions that are entitled to deference. They're making, in this case, the district court is making the same kinds of fact-informed judgments about whether there was grounds for a strike, specifically whether there was evidence of bias or evidence of an inability to follow his role as a juror. I'd argue those findings in a McDonough setting are entitled to the same sorts of appellate deference that you would if the voir dire had been done at the time of trial and the trial court had made those same findings. At the bottom of the analysis, it's the warden's position, Your Honors, that what McDonough is trying to get at, and what all the other rules that we've tried to hammer out to do a McDonough analysis, is whether the flawed initial voir dire allowed a biased or partial juror to sit in violation of the defendant's rights. I think that for the reasons we've discussed this morning and stated in my brief, that the district court's analysis on the absence of grounds for a strike for cause, either as a per se grounds, either as a specific grounds on each of the three questions, or on the seventh ground under the state rule for a juror unable to follow his role, are correct. But the fundamental question we'd submit is answered by the district court's finding that juror Treacle is not shown to be biased, was not shown to be partial, was not shown to have been seated in a way that would interfere with the defendant's right to have a fair, unbiased trial. And I think that's the ultimate finding the district court makes, that is simply its conclusion on the exhibits, the stipulations, and the day of testimony from all the witnesses.
He didn't just withhold information on one question. He did it on three questions and a lot of information. How far does the state's argument go? If there was a juror who withheld information on 10 out of 10 voir dire questions, is that okay? As long as he says, oh, you know what? Everything about every question y'all asked me slipped my mind. Is that still fine?
Well, at that
or
point,
under the totality of the circumstances theory that counsel for the opposing side argues, would we get there then? Three's not enough, but maybe 10 would be?
I don't know that there's any magic number. 10, I think, was the number in Sampson, but the question presented by a Sampson sort of analysis is addressed by the district court. It did say that it considered all the totality of the either false in the case of other law enforcement or omitted information in case of the other voir dire questions. It did consider all that. It could consider the evidence of motives. It distinguished cases like Sampson, one, because there was a finding in some of those cases, specifically Sampson, that the juror was willing to lie repeatedly. It found that this was not an intentional concealment, and that in Sampson there was other evidence of partiality or risk of partiality that, taken as a whole, led to the conclusion that the juror was subject to a strike for cause. Yeah, I think you do have to make the totality of evidence. I think the fact that those answers were not given, or were given incomplete, or were given incorrectly, is a factor the district court has to consider. I think a fair reading of its opinion is that it did consider that, and that it found, even in light of the number of questions that he failed to answer, that nevertheless there was not evidence behind them of an improper motive, of bias, or of other reasons for him to be struck, or of anything else that would have interfered on the record that was presented at the evidentiary hearing with Porter's right to trial by impartial jurors. May have a moment on my notes. If I may have a moment on my notes.
Sure, you go right ahead.
Thank you.
Mr. Dolling, what's the status of the Virginia death penalty statute?
The statute was repealed effective July 1st.
That's how's that impact this case, if at all?
Immediately, the statutes under which a death sentence could be carried out were also repealed. So there's no mechanism for carrying out a death penalty at this point in Virginia.
So what does that mean here? The sentence can't be carried out
A death sentence cannot be carried out.
under the present law.
Yes, Your Honor. It's not clear the way the statute was written, whether it was intended to have automatic effect. It says that any outstanding sentences shall be changed to life imprisonment. I think there's a question whether that was meant to be self-executing or whether that's subject to someone bringing a motion in the trial court to enter a changed order. To my knowledge, no changed order has been entered in Mr. Porter's
That
case.
might be subject to litigation then.
That might be.
Very good. Go ahead, finish your argument.
Thank you. The other point I did want to touch on is the district court did find, in answer to, and I apologize, I forget whose question it was, about the family members themselves being grounds for strike. In each case where a potential juror answered yes to one or more or all three of these questions, trial counsel did not move to strike them based on that, even in one case.
So
where
there were other jurors that answered yes to all three of these questions, that they had family members who had been in prison, that they had a family member who had committed assault, and that they had family members who were police officers or law enforcement?
But by the district court's count, there were two jurors who said yes to all questions, and both ultimately sat on the jury.
Two jurors that answered all three of those questions in the affirmative.
Yes. And one juror that answered the law enforcement question specifically with a father, brother, and son, and there was no motion to strike for cause.
There was no motion, so
No
the judge didn't have a chance to rule.
Yes, Your Honor.
And the judge didn't rule on his own, or her own. Okay.
But I think it does inform, to the extent we're trying to do a retrospective inquiry, what would have happened at trial had the information Mr. Treacle, Juror Treacle, did not provide, had that been provided at the time. So I think the district court's decision is supportable and should be affirmed based simply on the fact that there were no grounds for a valid strike for cause. But I think ultimately the analysis that there's no evidence of bias or partiality or other impairment to his ability to sit as a fair juror answers the underlying question, McDonough, and the other cases that are cited, and that habeas relief on that claim is not warranted, and the district court's decision should be affirmed.
Thank you very much, sir. We appreciate it. Mr. French?
Thank you, Your Honor. If I may, I just want to address, first of all, the two jurors who answered affirmatively to the voir dire questions, just to put it in perspective. One of those jurors disclosed that his brother had been mugged at one point. That the crime was that he had sold alcohol to minors 12 years earlier, and he had an uncle who was a corrections officer in Erie, Pennsylvania. The other juror testified that he had been robbed. He was arrested when he was 17 years old at a prom picnic, which the trial court made light of. And he was a consultant to HUD developing a security plan for public housing project. I would argue that these disclosures don't remotely compare to the volume of information that Juror Treacle failed to disclose. It also just bears mention the fact that you had one juror who mentioned the fact that he was arrested as a 17-year-old. Sort of puts, I won't say puts a lie, but Juror Treacle testified that although he didn't think about any family members at all, he specifically didn't think about the fact that his son had been arrested and spent time in jail and on probation on drug charges just a few years before trial. And he chalked that up because, well, he was a juvenile. Well, here we have another juror in his presence who's talking about the fact that happened when Juror Treacle's son was 16 or 17 years old. So again, it's one of those reminders in real time.
And his response to that was something like he wasn't paying any attention and didn't understand what the other jurors said, which goes to your argument that he's really was not up to the task of being a juror.
That's absolutely correct, Your Honor. I mean, he first of all says, I didn't think about them. I didn't listen to what they were saying. And when we asked for clarification, he said, well, I probably listened, but I didn't comprehend. These weren't difficult things to comprehend, that somebody has various members in law enforcement or had been subject to arrest.
But Judge Hudson said he's credible. And he credited what he said. And you have to convince us that it's clear error, that finding.
And I think it is clear error, when, Your Honor, when we just look at the, because I think part of what we have here, the benefit of, is not speculating about what would have impacted him when he was sitting there, whether things would have had an impact on his ability to be impartial. We have very facts that are indisputable. There were 3 questions that he just flat out didn't answer that were specifically calling for family members. What the district court in Williams v. Netherlands emphasized was the failure to answer the first question, honestly, needs to be viewed in light of the failure to answer the second question. And the failure to answer those questions need to be viewed in light of the fact that he also failed to disclose information in response to a third question. In that case, the prospective juror failed to disclose one family member or one individual with respect to.
Before you run out of time,
Sure.
What is the practical implication of what it is you're asking us to do if we do agree with you? What would happen? What happens next?
We think
if we
that
reverse.
the court would find that he was deprived of his Sixth Amendment right to a fair trial, and he would be entitled to a new trial. That would be the natural outcome. The one last point I want to make is about I don't think we're faulting anybody for the fact that it was 12 years after trial, but I will point out that that was not our doing, because we requested discovery in an evidentiary hearing back in 2009 and didn't get one until this court remanded it in 2018. When we talk about the fact that reasonable doubts need to be made in favor of the accused and not the juror, I think that's an important point to emphasize. To the extent there are faulty memories here, that shouldn't fall on Mr. Porter as the criminal defendant here. It should be used against the juror, which is entirely consistent with Virginia law.
The juror had a faulty memory from the inception, if you believe him.
And all that was taken into account by Judge Hudson.
Well, I think he took it into account, but as again, I would argue that all he was really crediting was after the fact of speculation and supposition, and really did not grapple with in any meaningful way the internal inconsistencies in Juror Treacle's testimony. With that, I'll conclude. Thank you.
Thank you very much. We appreciate the counsel's work in this case, and we'll take it under advisement. If we weren't still in this pandemic, we'd come down and shake hands with the council and tell you how much we appreciate what you've done, and welcome you to the Fourth Circuit, and hope you have you back. And I'll say all that. With that, we'll turn to, unless there's objection from one of my colleagues, we'll turn to the next case. You gentlemen may be excused. Thank you.
Thank you.
Thank you.
number 202266, Lee versus Hogan. Mr. Abbas,
Yes, Your Honor.
good to have you with us, sir. Pleased to hear from you.
Good to be here, Your Honor. May it please the court. This court should not follow the district court's lead in rewriting the executive order in order for it to have some kind of colorably constitutional interpretation. Instead, this court should give independent meaning to each section of the executive order that Governor Hogan issued. And when this court does that, it should start with the clearest section. Section B is the clearest section of the executive order, and it should be interpreted to mean, yes, Your Honor.
What if we start with the title? Because the title says it's a prohibition on discriminatory boycotts of Israel in state procurement. So like right from the get-go, isn't this order telling us this is about discrimination within the state procurement process rather than what you buy at Giant in your personal capacity?
Well, here in this particular situation, because Saqib Ali is an individual, he's also a sole proprietor in the context of government contracting. So there is no distinction between his personal capacity and his professional capacity in this situation. And that's the exact same situation that the Texas court confronted in Amawi, where it was a sole proprietor.
BDS activity related to his software engineering business.
Yes. So right now, Saqib Ali would like to bid on a state contract, and he would like to use his software engineering expertise. But let's say, for example, one of the state contracts that he found was about life insurance. In order to analyze, to create a software program for analyzing the life insurance policies, to provide a recommendation to the person at the state government that's in charge of that, he might have to acquire equipment. He would not acquire equipment from Hewlett Packard because of the work that they do with the Israel government.
How far along did he get in the bid process? Did he get any further than just identifying projects as is alleged in the complaints?
No, Your Honor. And the reason he didn't get any further than identifying projects is because the executive order itself flatly prohibits him from submitting a bid. He cannot, Section B itself says that in order to bid, you have to be, quote, not engaging in a boycott of Israel. And you also have to, in signing that oath, you have to promise that you won't boycott Israel, quote, for the duration of the contract, you'll refrain from a boycott of Israel. Those are things that Saqib Ali just can't do. He can't do that because of his political beliefs around boycotting Israel.
It just seems like he had no intent to bid regardless. Otherwise, he would have when the district court told him to.
And I think here the court should go back to the Supreme Court's oath cases and cramp.
The district court in that first order did it without prejudice, ruled without prejudice, and explained to him what he needed to do to establish standing.
Yes, Your Honor.
If he wanted to seriously pursue the case, here's what you have to do to have standing to sue. That's a constitutional requirement.
Your Honor,
and he didn't do it.
Your Honor, it's absolutely a constitutional requirement for Saqib Ali to have standing. But in all the other anti-BDS cases, in every single one, the moment of standing is conferred when the oath is presented. And in this particular context, if the proponents of this anti-BDS measure were successful in 2016 and 2017, it would become a state law. And probably the oaths would have been contained in contracts that were with independent contractors. But instead, it was issued by the governor. And because of the governor's limited power in the state of Maryland, that the anti-BDS provision only applied to state level agencies. And so because it applied only to state level agencies, the bid, Governor Hogan could have organized the law so that the oath is taken upon executing the contract. But instead, Governor Hogan made it so that the oath is required upon submitting the contract. And so that's where the exclusion comes. And that's the big difference between this executive order and the law in Arkansas, the law in Texas.
Am I
Yes, Your Honor.
misremembering? I thought in all those other cases, people did submit bids, sometimes without what you're referring to as the oath, but they submitted a bid. So what is going on here? Why is there no bid?
No, Your Honor. And so, for example, in Amawi, Representative Bahia argued that case. She did have a course of conduct of dealing with Pflugerville School District, but the standing came when she was offered a future contract and she refused to sign it. She didn't cross something out. She couldn't sign it because she was unwilling to sign an oath. And the court's analysis in Amawi
I don't
is,
understand how that has to do with why he didn't bid to establish standing as the district court told him he should do.
well, there's two reasons. One, and I think the Supreme Court's decision in Cramp and the oath cases that the Supreme Court deals with are telling here. The reason he didn't submit a bid is because he can't sign the oath. He cannot say that he is not boycotting. He is refraining from boycotting Israel now because he is.
But hang on a minute.
Yes, Your Honor.
There's no allegation in the complaint, I don't think, and the district court found there wasn't, and I didn't see one, that he is within the context of the procurement process discriminating based on Israeli national origin. I thought the only allegation was he doesn't buy Sabra and he doesn't buy SodaStream because when he shops for himself because of the connection to Israel. So I don't understand why he can't sign the certificate. It's not just that the district court is telling him to bid, it's that he's got the governor and the AG in court telling him, go ahead, sign the certificate. We don't think you're doing anything that constitutes a boycott of Israel. So I guess I'm just rephrasing the same question.
Sure.
Why can't this guy take yes for an answer, sign the certificate, submit a bid, and then we'll see what happens?
Yes, the reason, I understand that the crux of this case is, does Saqib Ali, having not submitted a bid, does he have standing to challenge the executive order? And that should turn on the compelled speech. When he's signing an oath, he is taking a position on the propriety of boycotting or not boycotting the state of Israel. That is speech. He is not willing to do that. And in Cramp, the Supreme Court talks about people that have Saqib Ali is a former state of Maryland lawmaker. He takes his obligations to the state of Maryland seriously. He's civic-minded. He's not going to say something that's not true. And in his mind, and in the plain meaning of the text of the executive order, it says a bidder needs to sign something, and agencies may not execute a contract with someone unless they say in writing that they're not engaging in a boycott of Israel. And he can't say that. He can't say that, and so he can't submit a bid. And that is the compelled speech component of standing that is similar to the other
Just so I
cases.
understand your argument, but the reason he can't say that is because on his reading of the executive order, when he doesn't buy Sabra, that is a boycott of Israel.
No, Your Honor, it's not just limited to Sabra.
I'm just using Sabra as an example of something one might purchase, and the one that is in the complaint as an example of something one might purchase in his or her personal capacity.
That is an example of something that he would not purchase in his personal capacity as an expression of his BDS activism.
I don't mean to minimize the importance of his personal boycott,
Sure.
but the reason he thinks he can't sign the certificate is because he believes it covers his personal boycott activity.
And would cover any business activity he does with the state of
But
Maryland.
none of that, but he has not alleged in his complaint any desire to, I don't want to use sort of normative language, but any desire to boycott Israel in the context of the procurement process. That's not in his complaint.
Well, and the reason there's nothing specific to a bid in his complaint is because he's disqualified from bids across the board. There's no caveats to the disqualification. And there's First Amendment doctrine that allows for pre-enforcement challenges. And I think that doctrine really fits this particular situation. here because it's not just whether or not, and there's a lot of back and forth between the parties about what the executive order does, what it doesn't do, but again, if you go back to section C, and the section C has the text of a oath that the state of Maryland imposes. Even if you look at it and you limit it to in preparation of the bid, if that's the only scope that this court believes that the executive order covers, in preparation for a bid would require SACIB not being categorically excluded from bidding on anything. And if that categorical prohibition is removed, then SACIB could identify a contract, something that he wanted to bid on, and he could then put together a bid. And what he's saying in the complaints is that he adheres to BDS principles, which means that if he's putting together a software system for a government agency, maybe he won't use Wix, a website, a platform that folks use to build online shopping websites. It's a company with connections to the Israeli government. Maybe he won't use that. He won't buy certain technology from Hewlett Packard. And that would be him putting together a bid and having that bid process reflect his BDS beliefs. But instead, what the district court wants to do, and it seems that the panel has some.
Is the relationship between his BDS activity and his software engineering business, is that alleged somewhere in the complaint?
It's
what you've just said. Is that somewhere in the complaint?
Well, it's synonymous because he doesn't have a separate entity. There's no separate entity. And for both executive order as well as procurement processes in Maryland, you can be a sole proprietor. And this issue of in your personal capacity versus your business capacity, this exact issue arose in the Amawi litigation. And when it comes to sole proprietorships, I think in specific, when it comes to sole proprietorships, this difference between in your personal capacity and in your business capacity vanishes because a sole proprietorship is the same.
I don't understand that. It's not, as I read the executive order, it's just saying that when you when you deal with subcontractors and vendors and suppliers in the process of submitting your bid to the state, you can't engage in what we'll call a boycott of Israel. But when you go to Giant to do your grocery shopping, do whatever you want. And I understand today your argument that actually your client would like to boycott Israel in connection with his bid. He wants to pick suppliers and vendors based on their connection to Israel, but I don't see that in the complaint. And the district court said also, I don't see that in your complaint. So I don't know what we're supposed to do with that now. The only thing I see in the complaint is in my personal capacity, by which I mean as a sole proprietor, but not putting together a bid for state procurement. My other purchasing decisions, I would like those to be informed by my BDS activity. But I don't see anything about I want to pick my suppliers and vendors based on their connection with Israel.
I mean, if that's the difference between standing and not standing,
the district court said that was the difference between standing and not standing, and it's not like anyone said, then let me amend my complaint.
Well, we do think that it is important for the Fourth Circuit to not allow the state of Maryland or anybody else to impose loyalty oath requirements on any residents of state of Maryland, anybody that wants to contract with the state of Maryland. And it's also, if you go to Section C, and this is where vagueness I think is really important here. If you go to Section C, it's not just, there is an argument back and forth, and obviously the state of Maryland is saying that this is their official position. But yes, the first sentence, there's that in preparing its bid clause that they want to describe the 68 other words that follow. But look at that last clause after the comma where it says, or taken other actions intended to limit commercial relations. That's a phrase that we've seen in a lot of these anti-BDS laws, and that's a phrase that's intended, we believe, the plain meaning of that is that it encompasses speech and the other purely expressive actions that comprise boycotts. And then to the extent to the extent that there's vagueness here, that's a basis for standing, because again, the district court wants to read section B completely out of the executive order. And there's no way to do it, because if you go back to the district courts, remember the district court issued 2 motion to dismiss decisions, one in October 2019 and then one, I believe, earlier this year. And the first motion to dismiss decision, one of the things that she said in distinguishing section B and section C is that section B has a present tense requirement. You are not engaging in a boycott of Israel. It has a future tense requirement. You will not engage in a boycott of Israel for the duration of the contract. And then C has a retrospective look at what you have done in the past. Those are 3 different things, and those are 3 separate requirements. And because an agency may not execute a procurement contract with someone that doesn't satisfy either point A, point B1 or B2, that means that it would be futile for Saqib Ali to apply for a contract because he wouldn't qualify for it. And the plain meaning of section B dictates that outcome. Thank you, Your Honors.
Thank you
I'll
very
reserve the
much.
time for rebuttal.
Thank you. You save some time. Yes, sir. Mr. Snyder? Good to have you with us, sir.
Board. Through your questioning, you've already touched on the absence of actual injury here. Also, counsel has touched briefly upon other ways to obtain pre-enforcement review, like through chilling or through a credible threat of prosecution. He more or less disavowed those theories of standing in his brief by accusing the district court of having tried to shoehorn his arguments into those standing theories. I think all of his eggs are in the loyalty oath basket and the Cramp case. And the Cramp case does say that when faced with a constitutionally vague oath, that one does have standing to challenge it without having to sign it first. But this is a very, very different case than Cramp. Cramp involves a classic loyalty oath. It requires public employees to swear their faith in the United States and to forswear giving any aid, abetting, support, or influence to the Communist Party. And the Supreme Court wondered aloud, what do these words mean? Could it mean that if you support any type of issue that the Communist Party also supports, that you run afoul of this provision? The court concluded that those terms were incapable of objective measurement. And now you switch to paragraph C of this executive order, which has been conceded is the only certification that would-be vendors have to sign in Maryland. And it couldn't be more different. It's very narrowly drawn, focused in multiple places.
Counsel, why isn't that a merits argument? I understand your argument for why this oath is not vague, it's less ideological, it's narrowly drawn, but that just seems like that's a reason why it would survive merits review. It doesn't seem like a distinction as to standing.
When we're talking about standing under Cramp and that kind of loyalty oath line of cases, I think in that context, the vagueness, the merits of vagueness tends to bleed into the standing inquiry, because the idea is that if the oath is so incapable of understanding that someone can't be required to sign it because they really don't know what they're signing. So I agree that we're here only on standing, but I do think when we're talking about the loyalty oath, the merits tend to creep in. At least that's how I read Cramp. But this is not a loyalty oath in any sense of the term, either in Cramp or in Connell, another case that plaintiffs cite that focuses on kind of ascribing to certain belief systems. This is very focused on the Maryland procurement process and just requires people to acknowledge and to state that they're not engaging in national origin
Government
discrimination.
had not disavowed Section B at the time of the filing of the complaint. So what is your argument that there was no chilling effect between the filing of the complaint and when the state decided to disavow Section B?
Well, it's always been a fact that that Section C is the only certification that is required, that people are required to sign. But otherwise, in response to your question, Can I ask you to restate your question?
Yeah. When appellant filed the complaint, section B, the governor was rah, rah, all about the executive order. This is going to strike a blow to BDS, BDS activity. So section B was still in there at that time. So
Correct.
why was that not a chilling effect on appellant's speech at
Section-
that time, before attorneys got involved and
Right.
decided section B can't stand?
Let's assume C is not even in this
Yeah.
executive order. All we're looking at is B. Even when you read the definitional sections into B, it is clear that it only would address business decisions. That's through the definition of commercial activities and some of the other terms in there. And Mr. Ali's complaint does not allege that he engages in, certainly not in discrimination against Israeli suppliers and vendors and subcontractors in the procurement process, and alleges affirmatively that all he does is boycott in his personal capacity. He draws a very clear line between personal capacity and business decisions. And he kind of has to do that, I think, because the general non-discrimination provision that exists some later on in the package of materials that one has to sign, I'm not sure how he'd be able to sign that if he were discriminating against contractors, vendors, and subcontractors, vendors, and suppliers on the grounds of their, on the fact that they're Israeli. That would be national origin discrimination. So I don't think he can engage in that type of discrimination. I think that's why it's not in the complaint.
Can I ask you just a question about your reading of the executive order? So is your position, how important for you is the governor's disavowal of Mr. Ali's reading of the executive order? Is your position that, look, this executive order is clear on its face, it doesn't cover personal capacity activity, or are you relying, at least in some measure, on sort of deference to the governor? It's his order and it means what he says it means.
Two-part answer. One is that, again, it's conceded here that Section C certification is the only one that would-be vendors are confronted with and have to sign. B does not appear, they don't have to sign anything with respect to B. So as a factual matter, you don't even have to get to the governor's interpretation of Section B, unless by your question, it's whether the governor's confirming that that's the only thing you have to sign. So I think, first of all, you've got to, it's factually conceded that C is the only one that anyone needs to sign. Once we get to construing B, if B were something that people also had to sign, well, then the governor's disavowal of the governor's position that B wouldn't obstruct Mr. Ali from bidding on contracts would then become kind of more front and central to this case.
Would you need it, or do you think B is clear by itself?
I think it's clear that it only reaches business activities. And given the allegations of the complaint, I don't see how Mr. Ali gets there. If we wanted to go and talk about other scenarios, there's some, B is a little bit different from C. It uses different words, but it's pretty clear, I think, that C and B are both focused on business activities. And Mr. Ali, in his complaint, does not allege that he engages in discrimination in that context. I just wanted to say one very brief point about Ex parte Young and the 11th Amendment. And that's that I like to keep in mind when I'm thinking about Ex parte Young questions, the whole reason why we have Ex parte Young, which is to separate suits against state officials from suits against the state as a sovereign entity. And so the whole point of Ex parte Young is to find the official within the state system that is making the decision that is causing the injury to the plaintiff. And that does two things. One is it finds a lower down state official, so you're not forever enjoining the governor and the attorney general, because we know from these cases that governors and attorney generals are always named as defendants. But also, it would give effect to the court's injunctive powers, because you need to identify the state official who actually can remedy the injury that the plaintiff has suffered. So in this case, if Mr. Ali has submitted a bid, and if it had been denied, we would know who the official is that needs to be enjoined if the court were to conclude that the certification or the executive order was unconstitutional. We would know who that official is that needs to be enjoined in order to give Mr. Ali the relief he seeks. It's not just enjoining the governor or the attorney general.
I hear it, and it would be, because as I understand it, the order identifies the people who are going to enforce it are the heads of the agencies who either give someone the contract or don't.
Yes.
Okay. I understand what you're saying, but I did want to give you a chance to address what seems to me like just a teeny bit of tension between your arguments on the standing side and then your arguments on the 11th Amendment side. Because over on the standing side, you, at least in your brief, are relying pretty heavily on the governor and the AG disavowing any interest in enforcing this against private activity. But then over on the 11th Amendment side, you're saying these people don't have anything to do with enforcement. Why are you suing them? So yeah, why don't you just thread that needle for me?
Maybe it's a distinction between interpretation and enforcement. We're saying that the attorney general and the governor do not interpret the statute that way, or the executive order that way. We read Section C. We know that Section C, as a fact, is the only one that is required to be that people are required to sign, and that B doesn't have anything to do with it. So it's disavowing the broad interpretation that Mr. Ali is asserting in an effort to establish a standing here. Now, the attorney general does have some enforcement powers here. I don't want to run from that. If Mr. Ali discriminated against Israeli subcontractors in the formation of a bid, but certified that he didn't, well, that could form the basis for an enforcement action by the attorney general, who has the authority to bring suits against people who falsely certify in the procurement context. But again, in this context, Mr. Ali has alleged that he only discriminates, or he only doesn't contract with Israelis in his personal capacity and not in his business capacity. So there's no risk of a false certification here that would implicate the AG's enforcement authority. Really, the disavowal point more goes to an interpretation of C, what the state's view is that this means. And as the district court confirmed, that it thought that was the plain language dictated that result, and that the state's interpretation of it is the most reasonable. Unless the court has further questions. Thank you.
Thank you very much, sir. Appreciate it.
Points, Your Honor.
Mr. Abbas, go ahead.
Thank you. The first is that in Cramp, Supreme Court case, however, that self-exonerating sworn statements, in this case, it would be, I'm doing the boycott in my personal capacity, conclusively demonstrate that this appellant could not possibly sustain injury. Essentially, the state of Maryland is saying what the losing party said in Cramp, that they could sign the loyalty oath and they comply with it. There's nothing inconsistent about their lives with the content of the loyalty oath. But the Supreme Court looked at that loyalty oath and said, it's irrelevant whether they can or can't actually sign it consistent with what they're doing. The issue is the fact that they're having to sign the loyalty oath. So when we get to Colby Richardson, another loyalty oath case, this one about state workers and a loyalty oath about not overthrowing the government, the Supreme Court specifies that the concern about vagueness is particular in the oath context. Quote, concern for vagueness in the oath cases has been especially great because uncertainty as to an oath's meaning may deter an individual from engaging, unquote, in constitutionally protected activities. That's this situation. Saqib Ali is not willing to sign an oath that disavows his longstanding political beliefs. And he's not just some, fly-by-night passerby. He is a person that for 2 years, when the legislature was considering an anti-BDS law, helped lead the opposition to that law. And then now we see an executive order, and he's interested, civic-minded as he is, in keeping the bid process open to everybody. And as an entrepreneurial, civic-minded man, sees an opportunity to engage in contracts.
Yeah, that second part's really important to you, because I thought you were about to go off on a track where you don't want to be, that this is someone who has deeply felt and generalized concerns with this executive order, because that's the concern here, right? He's never submitted a bid before. He hasn't submitted a bid yet. Everyone's telling him to submit a bid, but he won't, which gives rise to at least a concern that this is less about a desire to participate in the contracting process and more about opposition ideologically to this order.
Yes, Your Honor, that is a fair concern, but that is a summary judgment concern. At the motion to dismiss stage, Saqib Ali is stating emphatically, he will put together a bid. The thing that is, he's identified several bids, obviously those have come and gone. He will put together a bid. The thing that's stopping him from putting together a bid is the thing that he has to attest to on the bid itself. That is the impediment.
But put together the bid and don't sign it and see what the state does.
But we know what the state will do, because
We don't know what the state will do.
well, and I don't have the statute in front of me, but it is an incomplete bid, and Section B and Section C make it clear that you have to sign it. Section B says, on one hand, that the agency can't execute an agreement unless it's signed, and Section C says, on the other hand, that people submitting the bids have to sign. And this is important, this was a supplement to the appendix, the last statement that the state of Maryland has made about the meaning of the executive order came a few months ago when Ben & Jerry's stopped selling ice cream in the West Bank and other occupied territories. The secretary.
If they reject the bid, then you have standing.
Well, Ben & Jerry, well, I would love to represent Ben & Jerry, probably not. but Ben & Jerry's, the issue is what is the state of Maryland's understanding of the meaning of the executive order? And when that issue came up, the Secretary of State sent out a letter that was made public on behalf of the entire administration that they're going to review Ben & Jerry's contracts because they viewed the activity of stopping selling ice cream in the West Bank, which was a decision, is not a discrimination decision based on a person's national origin. It's discrimination. It's a decision to stop selling ice cream in a particular place. And they said that was subject to the executive order. That is unopposed. It was agreed to in the appendix, and it's the last word on what the state of Maryland means. Thank you, Your Honor.
Thank you very much, sir. We appreciate the arguments of counsel, and if it wasn't for the circumstances, we would come down and greet each of you personally and shake your hands. But in the circumstances, we won't be able to do that. But we're glad to have you here. You both did a fine job.
Thank you, Your Honors.
I'm glad to be here in person also.
Yeah.
Nice to see you both.
General, and he and his fellow parties are represented by Mr. Fenarelli.
Yes, Your Honor.
Good to have you, Mr. Fenarelli.
Thank you. Good to be here.
When you're ready.
May it please the court. My name is Joe Finarelli from the North Carolina Attorney General's Office. I'd like to reserve 5 minutes for rebuttal. The district court found the plaintiff to be a prevailing party entitled to fees and costs for obtaining a subsequently vacated judgment in his favor against the North Carolina Attorney General, the Director of the State Bureau of Investigation, and a single district attorney. In doing so, Judge Boyle misread the applicability of the Supreme Court's decision in Buchanan, ignored this court's decision in S1 and S2, and therefore committed error. As the court is familiar—
Judge Boyle ruled that this statute was unconstitutional.
He did, Your Honor.
And entered a judgment.
He did, Your Honor.
And that judgment was adverse to your clients.
It was.
And there was a notice of appeal filed.
Correct.
And after the notice of appeal was filed, the legislature decided to get into it and adopted a statute.
That is correct.
That amended tried to fix the deck and did fix, I guess, the defect, the constitutional defect that Judge Boyle identified.
It attempted to do so. Yes, Your Honor.
So how long was that judgment viable?
Well, it was viable, frankly, until this court vacated it during the pendency of the appeal.
I know, how long? It was viable from the time it was entered until when?
Judgment was entered in May. I believe the court vacated it in July.
Of what year?
Of the same year, 2020. It was
2020.
2 or 3 months old.
May 2020.
Correct.
Until
the briefing
when?
had not been, I'm sorry, Your Honor.
Until November of 2020? Is that what you
So
said?
it was July or August of 2020. We had not even begun the briefing yet at the time this court vacated the—
It was vacated in
order.
July 2020.
I don't recall whether it was July or August. It was around that time frame, Your Honor. Yes.
Okay. Then go ahead.
So under the American rule, as this court is familiar, parties generally bear their own fees and costs. Section 1988 of 42 USC does allow a prevailing party to recover fees and costs in contradiction of the American rule. But the term prevailing party has been established by the Supreme Court as a term of art. And there's language that the court has used in both Farrar v. Hobby and reiterated again in the Buchanan case that requires an enforceable judgment. The Farrar case discusses it this way: a plaintiff prevails when actual relief on the merits of his claim materially alters the legal relationship between the parties by modifying the defendant's behavior in a way that directly benefits the plaintiff. It goes on.
Under that definition, I don't understand why that's not what happened here.
Well,
Let me just finish. There was a judgment on the merits, and the district court found, as a matter of fact, that because of that judgment, the legislature changed the law to the benefit of the plaintiff. So what's the problem?
Well, the Farrar case goes on to discuss no material alteration of the legal relationship between the parties occurs until the plaintiff becomes entitled to enforce a judgment, consent decree, or settlement against the defendant. And because of this court's opinion, the en banc opinion in S1 and S2, that judgment never became truly enforceable.
Counsel, I know this case was, the Rehazudin case came down while this case was being litigated, but it seems to me we have quite recently addressed a very similar situation, and we held that even in the absence of an enforceable judgment, a plaintiff is a prevailing party if you get a court ruling in your favor on the merits, and then the challenge conduct ceases as a result of that ruling. So why is that not this case?
It's not this case because it did not involve the vacator of the judgment.
The challenge conduct ceased.
The challenge,
up.
the challenge conduct did cease. The plaintiff had filed a lawsuit.
Because of the court ruling.
Yes, the legislature did act in response to the district court's ruling. We don't dispute that. This is simply the fact of, and what distinguishes this case from the Reyes-Zudin case is Reyes-Zudin had an enforceable judgment.
And it was a $0 judgment. The whole problem in that case, the reason that was a tricky case is because she didn't have an enforceable judgment. She had a judgment for $0. The entire premise was that judgment by itself does not satisfy the prevailing party requirements.
As we read the Reyes-Zudin opinion, and I know Your Honor was one of the 3 panel members along with Judge Thacker.
I mean, if the $0 judgment by itself had been sufficient, we wouldn't have had a case.
Well, except that the different facts in the Reyes-Zudin case was there was a jury verdict that found that there was discrimination. And because of that jury verdict, the plaintiff would have been entitled to some sort of injunctive relief. There was then
that got mooted out. It got mooted out because the defendant complied with the jury verdict. And I don't see how that's not the same here.
Well, again, I think there's 2 primary distinguishing characteristics. One, the judgment, albeit a $0 judgment, was still a judgment that would have entitled plaintiff to some kind of injunctive relief. That judgment was never challenged.
It didn't entitle the plaintiff to injunctive relief. It entitled the plaintiff to $0. There had not been any finding about an entitlement to injunctive relief.
Well, you're right. There was no final judgment on the injunctive relief.
And one never happened because it got mooted out when the defendant changed its conduct in response to the judgment.
Well, the opinion, this court's opinion, doesn't discuss mootness, and it certainly doesn't discuss vacator either. I mean, I realize that's something of a technical argument, but the vacator of the judgment in this case is the other materially distinguishing factor between this and the Reyes-Zudin case. The fact that S1 and S2 says a vacated judgment, which did not happen in Reyes-Zudin. It was not vacated by this court on the grounds of mootness. The injunctive relief just wasn't issued by the court. The district court declined to grant the injunctive relief because it found when the parties were arguing the injunctive relief after the successful jury verdict, it found that the county's capitulation and transfer of Reyes-Zudin provided the relief that it would have awarded or could have awarded, and that was the reasonable accommodation that deprived the plaintiff of an entitlement to injunctive relief at that point. But the plaintiff still had her favorable judgment in the form of she had been discriminated against. Yes, there was also a $0 judgment for emotional distress, but that was not that distinguishes that case from this one. Here, there was an enforceable judgment up until the time this court vacated, and the effect of that vacator is based on S1 and S2. It invalidates the judgment and renders it unenforceable. And if the Supreme Court precedent and this court's precedent and district courts within this court's precedent is you need to have a consent decree, a settlement agreement, or an enforceable judgment. Mr. Grabarczyk and the class have none of those things. I think the other distinction to draw here is that, and I realize that this question goes somewhat towards the amount of the fees that could be awarded, but if you look at what the plaintiff received in the Reyes-Zudin case.
What was the reason for the district court dismissing the case as moot here?
Because the underlying claims were based on a statutory scheme that had since been amended by the district court. And the plaintiff in this case sought to challenge the constitutionality of the new system.
Amended by the legislature.
The legislature.
The statutory scheme was amended by the legislature, not the district court, right?
I understood Your Honor's question to be, why did the court?
I know your answer said the court amended the statutory scheme. I'm sorry, trying to correct.
I misspoke. The legislature amended the statutory scheme, but
But it amended it because of the judicial ruling of unconstitutionality.
We do not dispute that, Your
And
Honor.
that's what Judge Boyle found
Correct.
after the entry of judgment.
Yes, he mooted the case, finding that the underlying claims that had been litigated under the old scheme were rendered moot by the legislative enactment, and denied the plaintiff's motion to amend the complaint and allowed him to refile.
So if
Yes,
this
Your
is
Honor.
right, then I guess it follows that a party who wins a 1983 judgment against state officials, at least, will never get fees under 1988, because the state defendant can just litigate the case. If the district court agrees with the plaintiff, go ahead and make the change, no fees.
No, I disagree, Your Honor, respectfully.
How could you get fees?
I think what she said is exactly right.
Well,
You're going to gut this thing.
I think then it does depend
agree with
on
you.
what this, I'm sorry, Your
If
Honor.
we agree with you, we're going to undermine the whole system.
Well, I don't believe you would, Your Honor. Even the Supreme Court in the Buchanan case rejected the same equitable arguments, the gaming the system or deterring civil rights attorneys from bringing this sort of litigation. And it rejected it in the context of the catalyst theory argument, which is essentially what is they are asking to be done here. What the plaintiff is asking to be done is, I don't have an enforced.
Could you just tell me the hypothetical circumstance under which there might be fees? Like, why am I wrong that the state can't just do this in every case? Litigate the case. If it loses, file a notice of appeal and then change your conduct. Boom,
Well,
no fees.
I think the first distinction, I think the narrower distinction is the defendants in this case, albeit sued under 1983 for purposes of 11th Amendment immunity in their official capacity, are not the state. The state does not, these defendants did not amend the legislation that, or create the legislation.
Right, but it's the state who has to pay the fees. So let's just say,
Okay.
I mean, I don't think that really answers my concern that in any case like this, the state could litigate fiercely in district court, and then if it loses, file a notice of appeal, and then the next day the legislature can change the statute. So now there are no fees.
Except I would answer that by saying, Your Honor, that the state can do that now up until the time of the judgment. If it senses, and this is the catalyst theory problem that the Supreme Court rejected in Buchanan, you can take it all the way up to the courthouse steps, correct the deficiency, and there the plaintiff doesn't recover. Here, in the scenario you're describing, the plaintiff has obtained the judgment, but then it's mooted
You're saying
because
it's
of.
pretty bad already, so let's just go all the way.
No, that's not what I'm saying, Your Honor.
Okay,
What I'm saying is, although it's an equitable system, it's not a guarantee that anyone is entitled to fees. There's no guarantee because you may obtain a $0 judgment, even if you've vindicated the amount, the wrongfulness of the conduct. You may not recover fees because the state or the defendant capitulates the moment before the district court issues the order. You may not recover fees under the S1 and S2 case after the judgment has been entered, but this court vacates the appeal, and the effect of that, vacates the judgment. And the vacator of that judgment then essentially deprives the plaintiff of an enforceable judgment under the legislation. I realized that.
S1 was centrally concerned, at least the panel dissent, which is then incorporated into the en banc, very concerned with the idea that you would be depriving the defendant state in that case of its opportunity to vindicate its reading of the statute on the merits in its appeal. And so I'm wondering why that concern would apply in a case where the state legislature just says, we don't want an appeal, forget it, we lost, we're just going to change the statute. It's obviously unconstitutional. There's no interest left to be vindicated here on appeal. So it strikes me that S1 is a very different kind of case, because in that case, you had the state trying to appeal on the merits when the city kind of mooted out the case. But here, the state forewent an appeal. It just said, whatever, there's a judgment against us, we'll comply.
The issues that I believe would have been raised in the appeal, and again, we did not get to the actual briefing, but the issues that would have been raised in the appeal would have addressed the suitability of these named defendants as.
But you weren't challenging the constitutional ruling
Well, we hadn't briefed anything
on the
yet.
due process. I mean,
I thought
I suspect the Attorney General advised the legislature, you're dead wrong on the way you draw the statutes. You got to fix it.
I don't know of the communications that occurred.
Then we'll try to undermine this fee award,
I'm sorry, undermine what, Your Honor?
undermine the fee issue. But you definitely, you knew that you were wrong on the statutory point that where no process was provided. The sheriff decided everything. That was the end of it. So you challenged, you'd rather challenge on the 11th Amendment, which doesn't apply here.
Well, I'm not conceding that we would have not argued the
How could you
merits.
have argued the merits? The legislature already changed the law. What would that appeal have looked like?
Well, at the time we noticed the appeal, there was no legislative.
No, I know. And at the time you noticed the appeal, you did not notice any intent to appeal on the merits. But what I'm getting at is a slightly different question, which is I don't understand how the Attorney General or these ex parte young defendants have some interest in the validity of this law that remains to be vindicated on appeal here, given that the state legislature has abandoned the law.
Well, in part because the plaintiff had identified his intent to sue under the new legislation and has sued the same individual defendants and added, I think, at least one other that were sued in the instant case. So there was an interest in identifying, of course, which was mooted by virtue of the legislative enactment and the vacator by this court of the appeal, or the judgment and the dismissal of the appeal. There was still an interest in identifying whether these defendants were the proper party for any subsequent lawsuit, which has come to pass and been filed.
So you're not alleging, and I think I'm not being clear with my questions. So in S1, the dissenting opinion is deeply concerned with the idea that the state in that case would like to appeal and vindicate its understanding that it never did anything wrong. Its reading of the statute was the correct reading. And you are not arguing that there's any interest like that to be vindicated on appeal in this case. The interest that you point to is about who is a proper defendant and who is not. But it's not as though these ex parte young defendants have some interest in the validity of a statute that has already been changed by the legislature, right?
Well, true, but nobody had an interest in the validity of the statute that passed.
That's sort of my point. There's no interest left to be vindicated on appeal here. So we don't need to worry the way the court worried or the dissent worried in S1, that if we allow someone to be a prevailing party, even when the case moots out on appeal, we are depriving the defendant of its chance to vindicate its interest on the merits on appeal. That concern is not present in this case.
I agree that that concern is not immediately present, but I would point out in the short time that I have left that that is not the only justification of the S1, S2 en banc court as to why or what its holdings were and why it was concerned with the result. I'd like, since I have just 2 minutes remaining, I'd like to reserve the remaining.
Over 2 minutes, I think.
I'd like to reserve the remaining time for my rebuttal.
Right ahead. You save some time for rebuttal.
Thank you.
Mr. DeBelling?
Dubelling, Your Honor. Thank you.
Dubelling.
Yes, sir.
I'm sorry. I butchered a lot of names in my time here in this courtroom.
My name has been.
I apologize to you profusely. I do that.
Absolutely fine, Your Honor. Thank you.
Go right ahead, sir.
May it please the court. My name is Paul Dubelling. I'm the attorney for the plaintiffs below, and of course I represent the appellees here. Before I begin my argument, I'd just like to correct a factual assertion in the record. The briefing of respondents indicates that Mr. Grabarczyk remains on the registry. That is not true. As a matter of public record, in light of the new legislation, Mr. Grabarczyk was finally given a hearing on the question of whether he should be required to register as a sex offender. In that hearing, the Superior Court Judge of North Carolina found that he had been improperly registered and subject to an improper deprivation of liberty for 15 years. Mr. Grabarczyk is no longer on the registry as a direct result of this lawsuit. I would also like to bring to the court's attention a legal change. As I understand it, checking the record before coming in Riyadh, there was a petition for cert filed. That petition was denied, I believe, in late October. leaving Riazadin as the unchallenged precedent of this court. Your Honor, Mr. Grabarczyk won. He won absolutely and totally. He went to court. He proved that the state was acting in violation of the Due Process Clause of the United States Constitution. He asked for declaratory relief to that fact.
Okay, and then all of that was vacated. So how do you distinguish this case from S1?
The holding in S1 and S2 was precisely that when a case is mooted prudentially, you cannot become a prevailing party by virtue of post-dismissal events. What happened in S1 and S2, as this court is aware, is the case was mooted because one of three defendants reached a settlement agreement, and the court said, for prudential reasons, we're going to go ahead and moot this out, and vacated the case. There was no judgment in effect, and the facts of S1 and S2 are that the court, the change was made because the Department of Education threatened to remove funding from the state if it didn't change this policy. So as a matter of fact, there was no judgment at the time that the state took the remedial action. And as a matter of fact, it did not take the action in response to the litigation. Quite the contrary, it continued to fight the litigation and only capitulated when the federal government said, hey, regardless of what the court says, we're going to cut your education funding if you don't come on board. And what the dissent said, and ultimately what the en banc opinion said, was that causal connection, that idea that this litigation somehow set the ball rolling in a way that ultimately caused the federal government to get involved, to threaten to withhold funding, which caused the state to capitulate in the absence of any judgment at the time it capitulated, is simply insufficient to award a fees under 1988, Your Honor. So in this case, Mr. Grabarczyk won completely. He asked for declaratory relief. He asked for injunctive relief. And that's what the court gave him. As this court knows, that order was final. It was final because it was appealable.
And what the final for those of appeal to be filed.
Exactly, Your Honor. And so, as it's unchallenged in this court, this is a 1983 action. This is how 1983 actions work. The individual defendants are stand-ins for the state. This is a lawsuit against the state of North Carolina. And what it decided to do, looking at this judgment, is say, we're not going to pursue this appeal. We're just not going to do it. And so they changed the law. And then, when they changed the law and finally gave Mr. Grabarczyk the hearing, he won. So no matter which way you look at it, at the time, if you look at what the district court gave him, if you look at the ultimate outcome for Mr. Grabarczyk, he won this case. And however we formulate it, there are a bunch of cases you can pick and pull, you can pull all this. But at the end of the day, a prevailing party is someone who wins. A prevailing party is someone who obtains a judicial pronouncement on the merits of their case, which results in defendants remediating the action, modifies the behavior of the defendants in a way that benefits the plaintiff. Mr. Grabarczyk won a judgment on the merits of his case. He won it absolutely and completely. He won everything he asked for. The state here doesn't challenge, as a direct result of that ruling, they changed the law to give him due process.
You say they don't challenge that at all?
They said here in argument today, they do not challenge.
And the district court found that.
Yes, Your Honor.
As a fact. Was he entitled to find that as a fact, the district court?
I'm sorry, Your Honor?
Was the district court entitled to find as a fact that the change of the law, the act of the legislature, was because of the judicial ruling? Was he entitled to find that? Is that a finding of fact of the district court that's therefore entitled to deference on appeal here today?
Yes, Your Honor, and I believe as it is because this court in Riazadin specifically contemplated whether or not it should be sent back for that finding. When you read the Riazadin opinion, or perhaps look at the docket entries, one of the issues in that case was whether or not the court should just rule or whether it should send it back to the district court for that finding. Implicit in that is this court's understanding that that finding of fact, if it is important to the ruling.
The district court found that fact, and was the record sufficiently developed for him to be entitled to do that?
Yes, Your Honor.
You're saying it was?
Yes,
they haven't challenged it.
Yes, they don't dispute that here.
They don't
Two,
dispute
in the
it.
district
They haven't
court.
disputed it on appeal. And they haven't disputed today anything about the fees and costs.
Correct, Your
That
Honor.
hasn't been argued. The amount,
Not so far, Your
it
Honor.
might be in their brief. I'm sure it is in their brief,
And
summarily.
isn't reference to the federal court order contained in the legislative history of the House bill that changed the law itself?
Yes, Your Honor. In fact, the bill is 2020 North Carolina Session Law 83, Section 11C, I believe, specifically creates a process for the members of the Grabarczyk class. The reason it's not fairly in dispute is the legislature actually said, and with regard to the plaintiffs in Grabarczyk, we are giving them this process. It's just not a fairly disputable fact that the causal relationship between the judgment and the legislative act exists.
Counsel, can I ask you a question? It's more of a thought. Tell me if I'm right or wrong. So it seems to me that the position you're taking today, and as I understand it, it's that he won a judgment and then that judgment caused the defendant to change conduct in a way that was favorable to the plaintiff. That's what makes him a prevailing party. That actually seems like a narrower theory than some of our sister circuits have adopted. In some of our sister circuits, it seems like the rule is more generally, look, if you ever get a judgment in your favor, period, you're a prevailing party. We don't care if it moots out. And if it moots out, we don't care why. We don't care if it was because of a legislative change that gave you what you were looking for or not. Like it could be someone died, stuff happens. We don't care. Once a prevailing party, always a prevailing party. Your argument seems narrower than that because it actually turns on the fact that the reason this case mooted out is that the state decided to forego an appeal and give the plaintiff class what they were asking for. Does that seem right to you? That there's actually even a broader theory under here under which you could prevail, but you're not arguing that one?
Yes, sir. In fact, the mini circuits, 3 that I have at hand, Young v. City of Chicago in the 7th Circuit, Dolan v. Board of Education for Denver in the 10th, Doe v. Marshall in the 5th. In each circuit that has looked at that, besides the 4th, and I'll discuss that in a minute, they've said winning a preliminary injunction, which is later dissolved and mooted because of subsequent remedial action, would entitle you to prevailing party status. The DC Circuit, in the National Black Policemen's Association v. DC Board of Elections, specifically found that where an injunction was entered, which was mooted by a legislative change, which caused the appellate court to vacate it, to vacate the injunction, entitled them to relief. Without a finding in that case of causation. They just said, you know, a legislative change that moots it, that's remedial action by the defendants. You win. This circuit in this, I'm not sure how to pronounce it, Smythe or Smith, S-M-Y-T-H, did not follow the sister circuits with regard to preliminary injunctions with that, right? This circuit said, look, if you win a preliminary injunction and then the defendant moots the case, you're not a prevailing party. But the reason it did that is telling. It said specifically the only reason you're not a prevailing party is because a preliminary injunction doesn't involve a full hearing on the merits, right? They contrasted a preliminary injunction where there's not a full hearing to a situation where you have a full hearing. So in the majority of circuits, yes, you can be a prevailing party in more ways than you be the 4th Circuit. But in every circuit, when you win a judgment that results in the defendant's behavior changing to the benefit of your client, you're a prevailing party under Section 1983 and therefore entitled to fees under Section 1988, because that's the definition of winning. Frankly, Your Honors, absent questions, I don't have much more to say here. My client won. However you look at it, he got all the relief that he was entitled to. And this is exactly what 1988 is for. I guess I would end by noting that this is precisely the reason there are 1988 fees. There's an absolute and clear constitutional violation. Mr. Grabarczyk is subject to a deprivation of liberty in violation of his constitutional rights. He brings litigation that he can't individually afford to vindicate that right. He wins. He gets the due process. He is no longer subject to the deprivation of liberty. Mr. Grabarczyk's personal story highlights not only the importance of this litigation, but the importance of access to the courts. 1983 works. And as this court made clear in all of the cases, the purpose of awarding fees is to enable plaintiffs to bring valid constitutional challenges to state action, which is why the judicial determination of the merits of the case is the touchstone for the award of fees. Pending questions, I have nothing further, Your Honor.
Thank you so very much.
Thank you.
Appreciate it. Mr. Vinarelli?
Yes, Your Honor. I realized the mistake that I had made with the timing before. I appreciate the opportunity to make a very brief rebuttal. First of all,
you have 3 minutes. I'll give you 3 minutes.
thank you, Your Honor. First of all, there was an enforceable judgment, a summary judgment order in the S1 and S2 case. It did exist. It was settled by one of the defendants while the case was pending on appeal. But there was at one time, just like now, an enforceable summary judgment order that was vacated on appeal. I think the second and last point that I'd make is nothing about a decision by this court today reversing the district court and denying Mr. Grabarczyk and his attorney fees discourages folks from bringing 1983 actions. They are brought whether they can recover fees or not. They are brought whether the state capitulates, as the panel seems to consider what happened here. If the state capitulates.
That's what the district court found.
Well, the legislature.
Do you challenge that finding?
No, the legislature.
Okay, well, the district court found that.
We do not dispute that the legislature enacted legislation in response to the district court's decision. It would be impossible for us to do so given the text of the legislation itself. What we have argued is that the legislature is not the defendants in this case. The defendants have changed no conduct. The legislator, as separate executive branch, a separate branch of government. What you have as the individual defendants in this case are 2 executive officials and 1 judicial branch official. The judicial branch official is less connected to the legislature than even the executive branch, because the plaintiff's argument in the briefing was, well, the attorney general represents the state when there's a challenge to a legislative statute, or they have to report to the legislature activity in those cases where state laws are challenged.
Counsel, can I see, this is where I get hung up in your argument. I understand that the defendants here are not the state legislature itself. And that we could say maybe that the legislative action isn't exactly attributable to the defendants in this case, as we do in the vacature cases. But the reason the legislature did this is because the plaintiff won an injunction against the defendants who would have been required to take them off the registry unless the legislature changed what it did, changed the law. So I guess I'm still not, it was the judgment against the defendants that caused the legislature to do what it did. So why does it matter that they are separate in some kind of fictional sense? Because we all know this is really just a suit against the state.
It matters, and I realize my time is running out. So
you go ahead and answer your question, and any others you get.
Thank you. The distinction, Your Honor, is that the defendants here were pursuing the appeal. The district court's enforcement of the order had been stayed at the time. There was no obligation on the General Assembly's part in North Carolina to act the way it did. It chose to do that. It chose to enact the legislation that provided process that, again, plaintiffs have continued to challenge is inadequate. The fact that Mr. Grabarczyk, under what he claims to be inadequate process, was removed from the registry as he has originally sought in this lawsuit does not mean that he won, does not mean that the class is removed from the registry or that the class of offenders have been provided due process. That's the exact opposite of the argument he made at the district court when he wanted to amend his complaint. He hasn't won. He simply transferred the complaint about the old system to a complaint about the new system. And the defendants in this case had no role, and plaintiffs cite none in the record to what the legislature did. I understand the court has been concerned about the effect of, or the essential effect of what the legislature did. But the vacator cases and the mootness cases that we cite in the brief say that those actions should not be imputed to the executive officials.
But we're not
When-
imputed. I mean, I guess, and I'm sorry, I know you're over time, but I don't think your colleague is trying to impute the action to the defendants. He's trying to impute the action to the judgment, right? It's because of the judgment against the defendants that the legislature changed what it was doing. No one's trying to impute anything to the defendants.
Well,
And that's what Judge Boyle says in his ruling, in writing.
again,
And you don't challenge that.
there's no question that what the legislature did was in response.
After the entry of summary judgment and because of the judicial ruling,
Correct.
the legislature made a change.
We do not dispute.
So the
action.
legislature changed the law after the summary judgment because of the judicial ruling. Those are the facts of the case.
Correct.
Unchallenged.
Except that the case law from the Supreme Court on what constitutes a prevailing party talks about a material alteration of the defendant's conduct. It doesn't talk about a material change in the relationship of other entities that are affiliated with the state or are the state in the Section 1983 official capacity context. It says it has to materially alter the relationship between those defendants and the plaintiff. And again, I'm not here arguing that the legislation was not in response to the district court's order. I couldn't do that credibly and come back to this court with a straight face. But the effect of the vacator of the judgment, when this court vacated the district court's summary judgment order, it rendered it unenforceable for purposes of Section 1983 and attorney fee prevailing party status. And with that, unless there are other questions, I will graciously sit
We've
down.
been very generous with our
Thank you.
time with you. But we very much appreciate the arguments of counsel. And we will take this case under advisement and resolve it as soon as we can. The court will therefore adjourn, Madam Clerk, until tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank you, Your Honor.